5 seconds to go. Start. The Sessions Court has sentenced him to death, subject to confirmation by the High Court. He is not under sentence of death, even if the High Court imposes, by confirmation or fresh appellate infliction, death penalty, so long as an appeal to the Supreme Court is likely to be or has been moved or is pending. Even if this court has awarded capital sentence, Section 30 does not cover him so long as his petition for mercy to the governor and or to the president permitted by the constitution, code and prison rules has not been disposed. Of course, once rejected by the governor and the president and on further application there is no stay of execution by the authorities, he is under sentence of death even if he goes on making further mercy petitions. During that interregnum, he attracts the custodial segregation specified in section 32 subject to the ameliorative meaning assigned to the provision. To be under sentence of death means to be under a finally executable death sentence. Speaking for the majority in the concurring judgment, D.A. Desai judge stated thus, the expression prisoner under sentence of death in the context of subsection 2 of section 30 can only mean the prisoner whose sentence of death has become final, conclusive and indefeasible, which cannot be annulled or voided by any judicial or constitutional procedure. In other words, it must be a sentence which the authority charged with the duty to execute and carry out must proceed to carry out without intervention from any outside authority. In the light of the enunciation of law by this court, the petitioner could never have been segregated till his mercy petition was disposed of. It is only after such disposal that he could be said to be under a finally executable death sentence. The law laid down by this court was not adhered to at all while confining the petitioner in solitary confinement right since the order of death sentence by the first court. In our view, this is complete transgression of the right under Article 21 of the Constitution, causing incalculable harm to the petitioner. The combined effect of the inordinate delay in disposal of mercy petition and the solitary confinement for such a long period, in our considered view, has caused deprivation of the most cherished right. A case is definitely made out under Article 32 of the Constitution of India, and this court deems it proper to reach out and grant solace to the petitioner for the ends of justice. We therefore commute the sentence and substitute the sentence of life imprisonment in place of death sentence awarded to the petitioner. The writ petition thus stands allowed. In its jurisdiction under Article 32 of the Constitution of India, this court had thus deemed it proper to reach out and grant solace to the petitioner on both grounds, namely delay in disposal of mercy petition and solitary confinement for a long period. The period of solitary confinement in Ajay Kumar Pal, in violation of the law laid down in Sunil Batra, was from 2007 till 2014, that is, for nearly 7 years. In the instant case, the period of solitary confinement is for about 10 years and has two elements: one, from 2006 till the disposal of mercy petition in 2013, and secondly, from the date of such disposal till 2016. The question then arises whether on this ground alone the appellant is entitled to have the death sentence commuted. In Shatrughan Chauhan, solitary confinement was accepted and recognized as one of the grounds on the basis of which death sentence can be commuted. However, in the batch of matters under consideration in Shatrughan Chauhan, no benefit was granted to any of the convicts on this ground. Paragraph 88 onwards, The effect of the law laid down by this court in Sunil Batra and other cases was noticed, and it was concluded as under. It was therefore held in Sunil Batra case that the solitary confinement, even if mollified and modified marginally, is not sanctioned by Section 30 of the Prisons Act for prisoners under sentence of death. The crucial holding under Section 32 is that a person is not under sentence of death even if the Sessions Court has sentenced him to death subject to confirmation by the High Court. He is not under sentence of death even if the High Court imposes by confirmation or fresh appellate infliction death penalty, so long as an appeal to the Supreme Court is likely to be or has been moved or is pending. Even if this court has awarded capital sentence, it was held that Section 30 does not cover him so long as his petition for mercy to the governor and or to the president permitted by the constitution has not been disposed of. Stop.